Well, hello and welcome. What's today's topic? The EC heads to the Supreme Court for further clarification. But the general consensus is, are the polls in danger? Because constitutionally, after the 7th of December, we should vote on 7th of December. And there's so many processes that would lead, or things that have to be put in place before we lead up to this fateful day. However, we don't know our fate. But so many parties that couldn't make it to present a presidential candidate for elections. They think they've been disenfranchised unfairly, and therefore, rightfully, they need to seek, they want to hear or have their day in court. But when everybody is going to court, can we finish all these court cases and have a peaceful, fair elections where everybody will be satisfied that yes, everything was done? But the intriguing thing is there a competition of egos going on here? After the High Court granted PPP that no, you could go to the EC and have your forms looked at and probably do the corrections and see if they would, let you join the race. EC says no, I am going to the Supreme Court to seek further clarification. It is as if it is a personal vendetta. To those of us who are laymen, who don't have the legal brains and just looking from the moral and the emotional side of things and the panic as to 35 more days to elections, we're just sitting back thinking, what at all is going on? And to answer the question, is one of our Ghana's finest brains. When I come back from the break, I'm going to introduce him. Fine gentlemen, don't move. Well, thank you very much for staying. Well, my name is Nana Sakwa the Fourth, Akwemuedu Masahene, and also your host. And my guest tonight, well, it's like one of my favorite persons, if I may say, one of my favorite persons, Samson Ladi Ayenini, very young but legal luminary in his own right. Samson, you're welcome.
Thank you, Dan.
And I really thank you because Samson had a lot of work on his desk, lots of work on his desk. I said, look, I need clarification on this thing. Can you help me? He says, no, I'll come. So on the behalf of the viewers and I, we say massive thank you.
You're welcome.
Samson, but I need, even though we're going to do Supreme Court thing, this new craze about my institution where, any political campaign that, train that comes your way, we are now under pressure, as to, look, it's a gamble. It looks like the MPP will win, so endorse them. Oh, no, it looks like, Mahama is going to stay. So it's literally, we are all gambling to see, let me endorse one so that if he comes, I can then go and ask for developmental projects or probably something for my personal gain. Two school of thoughts as usual. Those who think, oh, yes, why? Chiefs are also citizens, let them endorse. And those who think, look, let them stay neutral so they can mediate. I don't know which school you belong to.
The school I belong to is a school in Article 42 of the Constitution, which says that every citizen 18 years and above and of sound mind has a fundamental right. In fact, our Supreme Court has elevated the right to vote to a fundamental human right. So that if you are denied it, it is as though you were not human. You are not human being, or less of a human being. So the Constitution says that if you are 18, you're of sound mind, and you're a Ghanaian, you're qualified to be registered and to vote. Chiefs who are Ghanaians are entitled to this universal adult suffrage. To that extent, they already take part in active party politics. Except that the makers of our Constitution also recognize the need to ensure that the ballot is kept secret. So you go through a voting process where there is a certain sanctity to the exercise that you engage in. So it's called a secret ballot. So that when you vote, I don't get to know who you vote for unless you want to tell me who you voted for.
It's not illegal though, is it illegal? If I say, oh, look, I voted for A.
It's not illegal.
Oh, okay.
Right. But whoever is facilitating the process for you to vote, i.e. the Electoral Commission and its officials, are required and enjoined by law to ensure that your vote and the secrecy of your vote is protected. So if they don't ensure that, you can take them on. But as for yourself, you have the right to declare to the whole world that, look, I'm voting for Simesi and nobody has any issues with you. In fact, elsewhere, and you will know better, they have exit polls. I'm going and I'm voting and I'm telling someone sitting by that I'm voting for A. So we are able to tell that at the end of the voting in this polling station, somebody is able to tell the vote even before it is counted. But we don't get to do that in our country. Now, the wisdom in protecting the sanctity of the ballot is what I would wish that the chiefs who have gone ahead to do these declarations would take a cue and advise themselves. Because when the makers of the Constitution didn't stop at 42, but moved on forward, and went to say, we needed to create a chapter dedicated to chieftaincy as an institution, and give the institution of chieftaincy some functions. Actually, if you read the Constitution, it doesn't say it is establishing the institution of chieftaincy, because it cannot claim to do that. The institution of chieftaincy predates our constitutions, from the very first constitution to the 1992 constitution. So you will see that in the Constitution, the framers use the language, the chieftaincy institution is guaranteed. So they are simply reaffirming what already exists. And then after they have found some roles for the chiefs to perform, including to be the custodians of our cultural heritage, and to ensure that what we call in Chapter 11 of the Constitution, Article 11 of the Constitution, we have what we call the hierarchy of laws of this country. And in the hierarchy of laws of the country, you have customs, which are part of the laws of Ghana. Some people, unfortunately, don't know this, but the customs of your particular traditional area constitute a part and parcel of Ghana law. Now, the chiefs have been given a duty to see how they can bring all of these together in a harmonious manner, and to ensure also that customs that are not dignifying would be done away with. So I find that the Constitution recognizes, in recognizing the very critical and sometimes sacred role that chiefs have to play in our, community, decided to say chiefs shall not engage in active party politics. And it's for good reason. Because the chiefs are supposed to be the ones that provide leadership to all of us in our communities. They are supposed to provide leadership that has no colors, party colors. Even at the helm of national politics, when the political leadership fails, it is the institution of chieftaincy that we run to come and seek to mediate, and to bring society back together. You see, it is not all the time that we are going to have the courts to come to the rescue of the nation, particularly when we get to, a point where, you know, we are almost slipping off. There are situations that the courts may not be able to intervene or may not be able to do it as swiftly as chiefs would do. And so you need to protect that impartiality. As for your neutrality, it cannot be guaranteed. But the impartiality that you need to bring to bear, you have a community where your members are entitled to choose by way of the rights of association and a right to do politics, to choose whichever political party they want to belong to profess that and to engage in it. But when they have problems, you are supposed to bring them together. So you ought to have a role that A will not see you as already belonging to Party B. So because there's a problem, I suspect you will pander towards Party B. So I believe that the more they do this public declarations and get into active partisan politics, the more they reduce the respect and the more they endanger the very institution of chieftaincy. So that when the time, at the times that we need to call upon them, we are unable to call upon them because they will not, we cannot trust that they will bring to bear their impartiality.
On Friday, Friday gone 28th, I think it was, the president was in our jurisdiction.
Okay.
And so the traditional council had to represent, and then the acting president, you know, was speaking on the behalf of the chiefs. So he went further to acknowledge the good works, which indeed is going on. Dumasa roads are being done.
Right.
Ajana is just next to me. They've had a beautiful school building, you know, so we acknowledge it.
Okay.
And, you know, the guy went, you know, and endorsed it, you know, JM Twaso and everything. And, well, fine, we acknowledge he's doing well. There's a clinic coming up in Apekusu, the roads. I mean, things are happening. So JM Twaso, no problem. But then he didn't end there. He then went further to say that every 40 days when we're performing Akwesida, we will go to the Black Stool room and perform some rites that would let Nanado's picture disappear from the ballot box and everything. And Samson, in all honesty, before I even speak, there was a message going viral that the NDC, the MPP and myself, or they're putting pressure on myself to get this guy to retract the statement. Now, there's two elements. I don't have any issues with him endorsing and acknowledging the good works. No problem.
Right.
That, you know, on television, it stands.
Right.
But I'm saying, to go further, to say we are going to pour libation and do this, that cannot stay. That we have to disassociate ourselves from it. And you know, if you're, say, you know, I think NDC Sujama is not being very fair towards me.
Okay.
Because yes, I acknowledge things are happening. We have said JM Twaso, but we can't allow the ritual bit to stand. And in all honesty, I don't even think JM himself would say, oh yes, that's a fair statement to make. I mean, I don't know. I mean, council.
No, I even think that even to say, you know, JM Twaso would actually be getting into the political fray. Because it's all right. And you ought to acknowledge if he's done something which is obviously good, of course, done it with your taxes, with our taxes, and it's something he's required to do. And if he's provided the leadership for that to happen, and sometimes, of course, it takes chiefs to go lobby for some of these things to be done. And if they are done, you ought to acknowledge that it's been done.
So let me give credit to Inisa Husseini, because, you know, he was very instrumental in getting our roads done. So Inisa Husseini, thank you very much.
So acknowledging that, there's nothing wrong with it. In fact, you ought to acknowledging it on behalf of the entire Edumasa, you know, community. That is perfectly right. But to move on further to suggest that you are going to use rituals against one, against the other, I think that is absolutely needless. I ought to be careful and choose my words, because other than that, I'll say it's shameful.
So I'm not being unfair.
I'll say you are not being unfair. You are trying to help to keep the sanctity that you deserve within your jurisdiction. Now let me be frank with this. When you called me, there's something I said to you, and it is true, that yes, I come to Joy, we get to work together, I have the privilege of your friendship, but I don't take it for granted. I know how to separate that from where you sit as a chief. So if you place a call to me, I process the call immediately as a royal call. And depending on how you deal with me, I have to now begin to separate what is going on and to say you are dealing with me on a certain level, and I ought to give that regard. So I can be frank with you, that literally was near impossible for me to agree to be here. But I said, look, how am I going to say I can't come? You've called me, I have to. And that's my training. That's how I'm brought up, to respect the elderly in my community, and more particularly, you can't say no when a chief calls. So that is the kind of sanctity we need to keep at all costs. So everything must be done to protect it. Other than that, like I said, before we went for the 2012 elections, we had to organize a whole summit and to get the Otumfo Asante Hene, to get the two major contending, gentlemen to come together to agree to a pact. I think 2008 we did it, right? To agree to a pact to accept the results. It took him to get the two to be there. Now, if you do some of these things, why will I want to answer to his call? If he's already shown loyalty to one party, I will not. When things are not going on well, how will he dare pick his phone and call me and to want to instruct me as a presidential, candidate who must have failed, to talk me to understand why I should give in and allow, things to go.
Very interesting topic,
Yeah.
but let's quickly move now to Supreme Court. But very interesting. So thank you very much. But you see, my viewers and I really appreciate the sacrifice you made for us.
But they reduce their respect when they do that. They reduce their respect and regard even among their own people, and that's not good.
I agree, because if you look at the language that followed afterwards, under no circumstance would that language would have done if he hadn't dabbled in politics. But it's easy being personal with the PPP. Is there something? Are they bone to pick? Are they egos? What's happening?
Well,
this is my big question.
Right.
This is my big question. Yes, there are legal implications, and everybody deserves their day in court. But this is the whole Ghana from Paka to Axim. By 7th of December, we need to vote. I mean, does it not come into play to say, okay, for the sake of the nation and the tension and how volatile we become nearer politics, look, let certain things go now. Next 4 years, we'll pick our bone. I don't know.
Well, Nana, I think that I'll begin on the note of what the Chief Justice had to say on the 24th of this month, of last month, when she gathered the judges of this country, lawyers, some civil society groups and leaders, and also political leaders and religious leaders, traditional leaders, brought them together under her forum, which is dubbed the Chief Justice's Forum. When she delivered her address, she made a note that disputes are a feature of the elections. They are things that you cannot do away with as far as there is a contest of ideas or two individuals having to go into a contest. You cannot do away with disputes. But the most important thing is how to manage the disputes so that they don't degenerate into violence. Because elsewhere we know what happens. Electoral violence obviously are a result of little disagreements here and there that begin to, degenerate into all sorts of things. And then she gave an assurance to the nation. First of all, gave a charge to her judges. Of course, they are her judges, whether they are in the Supreme Court and almost all the Supreme Court judges were there. She gave them a charge. She used two examples. When the courts were supposed to be on vacation between, the last 3 months ago, the courts were supposed to be on vacation for 2 months. Now, during the vacation period, a couple of cases came up. They were election-related cases, and somehow I was involved in one of them. Naturally, because it's a vacation, she ought to have said, well, it's vacation, so we wait when we resume courts, and that will be in October. And normally in October, it will be like in the second week of October. Meanwhile, the Electoral Commission had given a deadline of the 30th, 26th and 30th to receive nominations. And so if those matters were not resolved, it meant that those individuals who were parliamentary aspirants could not organize themselves and they could not put their nominations in. So here's what she did. She recalled the judge, wherever you are, whether you have already traveled and left the jurisdiction, come back to the country and go and sit in your court and hear the matter every day until it is dispensed with, and make sure it is done before the 29th and 30th so that people can go and also contest. And in one of the cases, the one that I was in, it was the Kwesi Mintim MPP primaries. Other than that, by now, they would not have had a candidate. That place would have been a place without an MPP candidate because they were fighting over their own primaries. They were unable to elect somebody to represent them. In that matter, the judge comes and uses some innovative ways without compromising the rules. And where the lawyers are clearly minded to give excuses, she says, I will not take any excuse. So we are compelled. Where the lawyers are asking that, let's do away with this, let's do away with that, she says, no, we'll keep to this and have this process done. In literally 1 week, the entire matter is finished. A matter that ordinarily you would have seen would have traveled, say, 6 months, even 6 years. There's a case in this country that took 40 years. 40 years. From Kumasi through to Accra to the Supreme Court. 40 years. And what was it about? It was about a man who died and left a little landed property, and how the family could take this property and divide it in a way that everybody would be comfortable. It took 40 years to have the case concluded. And in fact, in that case, when the Supreme Court finally delivered the final judgment, the Chief Justice made a comment and she said, this represents a parody of justice. Parody of justice.
What's parody? What's the meaning in English?
To say this is ridiculous. What is that? Is this a justice we are asking for? The people who were supposed to be, some of them had died. In fact, some of the judges who sat in the matter had all long gone. So what's the value of what you are fighting over, really? And if it has to take you 40 good years to finish the matter, what's the essence? So she uses this example of this case, which I refer to, one of which I was in. Within 1 week, literally, the case is done. In fact, the trial itself took 3 days. We're done with the trial. And these were two cases consolidated, brought together. and all the parties asked to come to one court. One was in Secondary, brought here in Accra, put together. So she said, that example is how I want you to run the cases when they come as far as the presidential disqualifications are concerned. So she gives them that charge and then moves ahead to now assure the entire country that you can be assured that December 7, if we all cooperate, will not find us in a constitutional crisis. And December 7 is non-negotiable. January 7, you must have a president sworn in, because the Constitution, the framers of the Constitution, did not contemplate a situation where you would need to extend the life of a president, of the term of a president. So the term ends. It ends without any more. It simply ends, and it cannot be extended. It is only Parliament's, life that can be extended, and even that, the extension is just for a very short period. So I say, I cannot even begin to contemplate a situation where we are unable to have the elections on time and unable to have a president, and therefore we have a constitutional crisis. And who fills the vacuum? I cannot contemplate that, because I don't know how we are going to go around that kind of novel situation. So at all costs, the elections must happen on December 7. The rule is that the elections can happen before, but not after. Because the life of the parliament that we have also expires. Parliament is dissolved and everything goes. So you are not the only one who is concerned and afraid. Many Ghanaians are, and they are not because someone is simply, whipping up or causing fear and alarm unnecessarily. Because the Electoral Commission chairperson herself, she put in some of the documents she put in the court. She wrote in there that if care is not taken and things move the way they are moving now, if the suits come the way they are going, then we are going to have the calendar further derailed. And that is a danger no one wants to think about. So you are right, and everybody is right to panic. But the manner in which those who are going to assert their rights, the disqualified candidates, they are doing the right thing, because that is the only way to vent without violence. So they are doing the right thing. But your question now turns on, after Dr. Indum gets the victory, why is the Electoral Commission back in the court when it should have been the one to be quick to accept the judgment or the ruling and say, look, let's move on with life? I say, when you look at it critically, there are two sides to the situation. And it may not be the case that someone has a personal problem, because the matters are being fought in the High Court. The decisions of the High Court are not binding on the other High Courts. The High Court is what we say is a court of coordinate jurisdiction. A judge sitting in High Court A has the right to exercise the discretion in the manner they feel on the facts of a case is suited. A judge sitting in High Court B is not bound to take the decision of High Court A as a precedent.
On a similar matter?
No. It is the reason Nana Konadu went to Justice Kumson's court. And Justice Kumson said, you came by judicial review. You came invoking the supervisory jurisdiction of this court. You came invoking that and adding a human rights enforcement, right. You are wrong. You should have come by a petition. Then Indum goes to Justice Chebafor's court. He says, you are right to have come by judicial review. Absolutely right. And the Electoral Commission's argument that you should have come by petition is patently wrong. But also goes ahead to say that even if you wanted to come by a petition, you could come, but not in the way the Electoral Commission is suggesting. Because the Electoral Commission's argument was that even if you are coming by petition, which is the only way you should come to the court to assert your right over the disqualification, you can only come after the elections. So the only way you come to the court is to come by petition. But the petition is premature now until the elections are over. Then you come and fight it. Justice Chebafor says that is absurdity. It won't happen. You can come by petition, but under these grounds. You can also come by judicial review, but under these grounds. And Indum came by judicial review and has come under the correct grounds. And therefore, I'll listen to him. And then he listened to him and granted his prayer. Justice Kumsin said, no, that's not how it ought to be done. On that score, I say, going to the Supreme Court may in the end prove potentially to be the most certain manner in which to deal with the cases.
So that all the high courts have to go with that ruling?
So that some of the disqualified aspirants who have not even gone to court yet may not need to go to court. Because if the Supreme Court rules, for example, affirming Dr. Indum's victory, a number of things will play out. Number one, the Supreme Court is supposed to determine whether or not, if one wants to come, they have to come by petition or they have to come by judicial review. When the Supreme Court gives its decision, it will be final. All other high courts have to obey that procedure. So if you are a disqualified presidential aspirant and you are now to go, you know the court says you should come through this way. That's the Supreme Court saying. Number two, if the Supreme Court heard the case, in the end, it will determine one thing too. What errors or mistakes is the EC permitted to invite you to come and make corrections? Is it every error that you are allowed, the EC should call you to make a correction, or that the EC should not call anybody to come to make any corrections on errors that border on crime? So if the Supreme Court says, if your error is an error that borders on crime, because we have found that in Indum's case, ASEDA has subscribed for you here and the other region, and the signature appears to have been forged. That is crime. If it borders on a crime, you should not be called to correct. The only thing you can correct will be pure clerical errors, administrative lapses. If that's what the Supreme Court will say, then you would find that for a good number of the other candidates, it affects them. So they will get to know that, well, we are going to the High Court trying to say that this one, they should call us to correct it. Supreme Court already says, this one, you should not be called to correct it. So if you go to the court, you are wasting your time. And if you're already in the court, your case will be dealt with in accordance with what the Supreme Court has said. So that will now bring certainty. And then going forward in future, when you are presenting your nomination papers, the EC knows it's...
If the Supreme Court rules, the High Court is obliged to abide with those rules?
Without hesitation. You must follow the Supreme Court. When the Supreme Court says, this is the law, that is the law. If you say something else, yours will be thrown out on appeal. So if it says it is petition, people will know it is petition. If it says it is either petition or judicial review, and these are the grounds on which you can come, it becomes settled. People know how to go. If it says these are the category of mistakes or errors that you should be called to correct, we will be certain with it. If it is about a borders on crime, you should not be called to correct. We'll be certain with it. And then going forward, in future, the EC will know its powers and where it will not work to exceed those powers. The High Court says the EC set nomination day, but did not set nomination period.
On that note, because that's what we're going to come to, what's the difference between a nomination date and a nomination period? How does it work? Is it not the same? You know, the date and the period. How does it work? Stay tuned. We're coming back. Well, thank you very much for staying. EC heads to Supreme Court. Are the polls in danger? And before I come to studio and speak to my brother Samson Ladi, private legal practitioner, let me go on the phone and speak to Mr. Yusuf Ayuba, who's a deputy director for communication at the EC. So, you know, this is the inside man himself. Mr. Yusuf, you're welcome.
Nana, good evening.
Good evening. Good evening. How are you? And welcome.
I'm doing fine. Say hi to something for me.
I'll say hi to something. Hey, you're doing fine. But I'm panicking. How can you be fine when I'm? You see, are we going to vote come 7th December?
Oh, Nana. Hopefully, we will definitely vote come 7th of December.
Well, just before you came on there, you know, my legal luminary in the studio was saying that the rate of election should be out 30 days before election. As we speak now, if you look at things, maybe we'll have to probably skip the rates of election and just go ahead and vote.
Nana, as we speak, we are currently printing the rate of elections for the parliamentary election. So we'll need a deadline for the parliamentary election. Because the issue of the presidential, election is in court, we would wait till we exhaust that process before we can come up with the notice of poll, because we must do the voting and know exactly where the candidates would be on the ballot before we can produce the notice of poll.
You just said the panic word, wait. I think at the moment that's the panic word in election, wait. If somebody say wait till when?
We're hoping that the case would be disposed of as quickly as possible, so that we would be able, to come up with the notice of poll, and also ballot and print the ballot papers for the presidential. Everything is ready for us to, by close of week, we would start printing the ballots for the parliamentary elections. For that one, it's a bit complex because in all the 225 constituencies, we have different candidates contesting. So every constituency would have a different place. So we've been able to do the balloting for the parliamentary elections, and we know exactly where the candidates are in each of the constituencies that we have. So we would go ahead and, print the ballot for the parliamentary and await the court decision, so that we can also do same for the presidential election.
Mr. Yusuf Ayuba, there's a school of thought, there's a section of society who think that, look, there must be something the EC has against PPP. Is there a bone that you're picking? Is there egos? What is the EC trying to prove in trying to nail the PPP?
That is never the case, and you would know that it is not only the PPP that we did not accept their nominations at the end of the nomination period. So it can be true that we have a particular bone to pick with the PPP. They took us to court, and the court ruled, and the commission disagreed with the ruling of the High Court judge, and took a decision that they will seek for a review at the Supreme Court. So that is what we are doing. The commission has nothing personal with the PPP and the other candidates. It's a matter of the procedure in which they did not, comply with the procedure. So that is why we are in court. It's nothing personal.
Okay, you went to the High Court. They won the case at the High Court, the EC is going for further clarification at the Supreme Court. It's within your right. But at the moment, your legal team is overwhelmed with suits. So couldn't you have just let it go? I mean, do you want to add all these suits, on top of the already, burdened business of the core election mandate?
Nana, I'm sure that is their work. They know exactly how to, maneuver to deal with all these cases. It is in their domain. That is their competency. And the commission is very sure that they will be able to, work and make sure they defend the commission as much as possible. But
they've missed a couple of court appearances based on being overwhelmed with suits. So I mean that is a bit worrying.
Nana, I'm not competent in that area, and I think that we should leave that to the lawyers. They know exactly how they will be able to deal with all these cases in court.
What are the implications for the presidential elections if the rates of election is less than 30 days? Are there any implications? What happens then?
If there were not to be any case in court and we delay that one, it will be understandable. But as we speak, we are hopeful that we'll be able to meet the deadline for the parliamentary. But because the case is still in court, we cannot go ahead because we do not even know the number of candidates who will be on the ballot as we speak. So we would have to wait for the determination of the case in court. Then we can know exactly how many are contesting before we can come up with the notice of school.
What is the realistic minimum time you need? Look, Nana, they need to give us at least 5 days. Anything after 5 days we can print, or at least 2 weeks. Anything after 2 weeks, there's no way we can come up with the papers. What's the minimum time the EC can work with?
Now we would for the presidential, it's one constituency, yeah. and we are not dealing with only one printing house. So we would as soon as the case is determined, I'm sure within 2 weeks we should be able to print all these.
So the deadline is 2 weeks. After 2 weeks, we'll be stretching it. If, let's say, the last court, because I hear Apollo is taking his briefcase, APC has also picked their files up, and they are all up and down in court. If they give you 10 days to elections, say, okay, this is the ruling now, go ahead, EC. I mean, 10 days, can you pull it off?
We should be able to do that because this is not the first time we've dealt with these printing houses. They have the experience. And they will be able to come up with the ballot because the difficulty is that if you are dealing with parliamentary, because in all the 275 constituencies we have different candidates, that will be a difficulty if we were not able to do the balloting and go ahead with the processes. But thank God we've been able to deal with that process and the way is clear for us to start printing the ballot for parliamentary. So when it comes to the presidential, it's just one template. So or if it is shared among the various printing houses, we should be able to come up with the ballots for the election.
Mr. Alhassan Yusuf Ayuba, thank you very much. Thank you. Well, kota 10 days. Hope, the word I fear most, the two words is hope and wait. It sends shivers down my spine.
Yeah. You see that we've now gotten to a situation where, and as he rightly said, because of the circumstances, you cannot hold them to be breaking the law. Because it's not as if somebody is willfully doing something. So you cannot hold them to be breaking the law. So if they are supposed to issue rate of elections or notice of elections and all of that is not happening within a certain time, it is because of a situation. And you see, this is a most interesting scenario. Normally, when lawyers go to court over issues, we are in a hurry, often, to go and take an injunction against the person we are fighting. But in this case, you can see none of the lawyers is interested in asking the court for an injunction because the EC has self-injuncted itself.
Who do I put on? Who do I take?
Yes, because it will not make economic sense to do it.
But sorry, could the EC then argue in court that, look, Mr. Supreme Court, I've already printed this thing. It cost the state 300 million. If you add him, there's another 600 million from the state. You can argue.
No. Remember, Ayi mentioned the assemblyman who took the Electoral Commission to court over his disqualification sort of in the assembly elections. Yes, he cost us how much? 317 million Ghana cedis. The Supreme Court said, well, since you have broken the law, get the guy back. And without the guy, there should not be elections. And 317 million went down the drain.
So,
and Nana, that is a case I will use to illustrate something for you, for us to end. I don't know how you are doing it, but I'm looking at going back to the question of nomination day and nomination period, so that we don't forget and finish up on that. So we are clear that the Supreme Court will bring certainty and finality to how to commence a process, petition or judicial review.
We have 5 minutes, and I want to also wrap.
Right, and then it will determine what sort of corrections should you be allowed to make, because even the representation of the people's law says in section 28 that if you are found to have delivered to the returning officer, nomination documents that, there's some forgery in it, it's an offense which is punishable. And the punishments include that you'll be banned from voting for 5 years after you have handed your sentence. So the Supreme Court will determine if it's just an error, clerical, or if it's a crime, you should still be allowed to correct. We'll deal with that. Then third and most important, which is the basis on which Indum won this case. The High Court judge says EC set nomination day on 29th and 30th. It did not set nomination period, because by the way the law is structured, the judge says the law expects that the EC would have set nomination period. Say if nomination period is 40 days, then the EC could have said on the 30th day is a nomination day. So that's where it ends. You bring your papers. Then the remaining 10 days, I will use those to look at peruse your papers, and then if you are mistakes, I will call you to come and correct them within the 10 days. But the EC only set nomination dates. It didn't do nomination period. The EC says, no, you're wrong. So they are in the Supreme Court saying there is an error apparent on the face of the record, because in paragraph 8 of Dr. Indum's affidavit in the court, they stated that nomination period was from the 8th to the 30th of September. So even Dr. Indum knew that there was a nomination period. How come the judge is saying there was no nomination period? Do you get it? So on that technical point, they are in the Supreme Court, telling the Supreme Court to tell the judge who gave this ruling that he is wrong. You get how it works? So when all of these things become known, it might affect all the other cases, and then we'll know how to deal with each of them with finality. Now, the last point which I wanted to make, which I said I'll use the Mensa case, is that a very important, significant legal person in this country, he's known by the name Dr. Bimpom Buta. At the Chief Justices Forum, he stressed on the need to use what we call ADR, Alternative Dispute Resolution. It's an area of my specialization in my master's degree. Now, he says in the Imensa case, he found that if we had been amenable to ADR, we would not have had that case. It would not have come to court and would not have suffered that cost. So, isn't it possible that the EC could have looked at this ruling and used it as a basis to do ADR, call all the other parties who are not happy and who are going to court to come to the table and sit down with them within 1 hour, 2 hours, bring in some very important people, sit down and sort out and solve the issues, because time is of the essence. Then we moved on. Because the judge said one thing in that ruling. He said, if you intended to give anybody an opportunity of hearing, and the hearing did not result in amendments or corrections to that person's nomination form to bring it in compliance with the law, you didn't give the person a hearing at all.
But couldn't the hearing affirm that, no, you're not allowed to be on?
And that's what they challenge, that the hearing, and the judge says, the hearing should result in corrections that brings your forms in conformity. But if the AC try to do it today, who will he pick and who will he say you are not entitled? So maybe a Supreme Court is the best way forward, and it will cut short all the processes. They are going one by one. If they had gone as one group, the cases would have been dealt as one. If they had gone all in 1 week, the courts would have brought all the cases together and consolidated them. But they are not doing it that way. So maybe this Supreme Court case will cut short all of that.
Well, Samson, thank you so much.
You're welcome.
Viewers, I always give you the number, is 024-366-2001. It's not to call the show, but to call and order one of these nice shirts that I wear on the shows by Tantis Fashion. They're just by Yao Clinic. Give them a call. Wherever you are in the country, they'll ship your attire to you, male and female. 024-366-2001. Tomorrow we'll be back to do this all over again. But once again, thank you so much.
You're welcome.